Welcome to Consumer Law, What is it good for? Where we look at, consider and try to answer questions put to us at Stormcatcher Law, either via our free advice helpline or from clients. And today's questions, of which there are two, are as follows. The first is, my finance company has declined my vehicle rejection because they say the problem was caused by drive-on damage and an element of wear and tear. Can they do this? And the second is the car dealer has refused liability because of a repair carried out by a third-party garage. Can they do this? So in a nutshell, the two questions are asking whether drive-on damage, wear and tear, and unauthorised repairs or repairs carried out by a third-party garage are get-out-of-jail-free cards for car dealers and car finance companies. So, as usual, by way of an explainer, let's look at what these terms mean one by one. So, drive-on damage is a shorthand or perhaps lazy way of referring to the defence of contributory negligence. This means that they are suggesting that you have done something or not done something that you should have done, which has contributed to the damage that your vehicle has suffered, so as to eliminate or reduce the liability of the seller, the car dealer or the car finance company. The usual explainer that people give, or the example, which is perhaps not particularly pleasant, is the example of a seatbelt. If one was to have an accident, a collision in your car, and you were not wearing your seatbelt and suffered harm, there is a reasonable chance that you have suffered more harm because you didn't wear the seatbelt than you would have done had you been wearing one. And in consequence, your insurance claim for personal injury will be reduced by a percentage. Wear and tear is sort of what it says on the tin, but what the dealership or car finance company is saying is that the vehicle isn't defective at all, it's not faulty, but simply that the part or parts have reached the end of their natural and expected life, and they require replacement simply as part and parcel of routine servicing and maintenance, which is your responsibility and not theirs. Third-party repairs, or often referred to as unauthorised repairs, refers to the law of new and intervening acts, which again is a defence, and it is where it is suggested that a third party, in this case a garage, has done something which has broken the chain of causation so as to prevent the car dealership and car finance being responsible. It is another act which has intervened between you and the seller. And car dealers often will say, well, because you've had unauthorised repairs by a third-party garage, it can't be us, it must be them. So first of all, each of these defences are valid. They exist in law. The question is whether they apply in your case or these two cases, and whether by simply mentioning these terms is enough to trump your rejection or repair claim. And the short answer to that is no. The big issue here is all about the burden of proof, which no doubt you've heard many, many times, and who is required to provide evidence of and prove what. The central principle, the starting point, is that the claimant, so you, if you're making a rejection claim, bears the burden of proving your case. But this burden of proof is magnetic, for want of a better word, in that it shifts from one party to the other. So if one party makes a claim, you're saying the car is defective or faulty or been missold, then to some extent or another you have to prove that, depending on whether the problem happened within the first 6 months or after. However, if somebody else was to raise, for example, an alibi, if we've seen on television the criminal law programs, then of course they will bear the burden of proving that alibi. So in the case of these defective cars, let's give ourselves an example. So in the case of the Consumer Rights Act, if a breach of contract occurs, or to be more accurate, if a non-conformity occurs within the first 6 months following delivery, you, as the consumer, must provide documentary evidence that shows the vehicle is faulty, or it's been missold or misrepresented. Once you have provided that evidence, so you're going to need some sort of report or something from a mechanic that says they've looked at the vehicle, they've seen what the problem is, this is what the problem is, and this is what it's going to cost to repair. Once that's done, the consumer, you, has the advantage of the presumption that that problem, that fault, was there or developing at the point of sale. So that's part of the heavy lifting done for you. On the other hand, the car dealer or finance company may provide evidence that either the vehicle wasn't faulty on delivery and there was no fault developing, or you've done something or not done something that you should have done that's caused the fault. So we can see how the burden of proof shifts. You provide evidence, that's your responsibility. They have the responsibility, should they wish to take advantage of it, of providing a defence. And they have to prove that. They have to provide the evidence. So if we apply that principle, which seems to be forgotten by many car dealers and car finance companies, to our three examples, when a finance company, for example, raises the defence of drive-on damage, which happened in our first question, the dealer or the car finance company bears the burden of proving that the defence of contributory negligence is available, because not every defence is available to every set of circumstances. Once they've established that it is available, and by mentioning it they assume that it is, they have to then go through a process of proving what the cause of the damage is. So you need to know what the damage is, then you know to find out what the cause of the damage is, and crucially, what proportion of the damage was caused by the alleged drive-on, the contributory negligence. The idea is that somehow this problem has either been caused or made worse by you continuing to drive the car after it became faulty. It is not going to be enough for an expert or one of these vehicle inspection agencies or a car finance company just simply to say drive-on damage, and that somehow is a defence that's going to be completely extinguish their liability. That is not the case. If we then look at it in the case of wear and tear, it's a very similar process. You say the car is defective, you've provided the evidence. They say it's not defective, it's just simply a part that will wear through time. It has worn through time. It's at the end of its natural life. The car dealer or the car finance company has to prove that. They have to prove what the part is that's failed, and your report or your initial evidence may help them with that. They're going to have to establish what the expected lifespan of that part is. They're going to look at what could affect that lifespan, and they're going to need to establish that the part that they're referring to has simply reached the end of its natural life, rather than fail prematurely or through accelerated wear. I gave an example in a previous video of tyres. We've referred to tyres as being wear and tear parts because they wear through time and will have to be replaced periodically. But it is feasible, if I bought a new car today and in a week's time it needed 4 new tyres, even though that would be slightly odd, it is possible that I've been out donutting that car and wheel spinning it and caused those tyres to wear prematurely. But it's also possible that the tyres themselves were defective, or there's something wrong with the car that's caused the accelerated wear of the tyres. It cannot just be written off to say because they're wear and tear parts, all bets are off. Similarly, if we look onto the third element, which is unauthorised repairs, that's repairs carried out not by the dealer or car finance company, and not with giving them the opportunity to do so. You've just simply taken it to another garage, They've carried out some repairs, something else has gone wrong. You've complained to the garage or finance company and they've blamed the third-party garage. It's not going to be enough just to blame somebody else. The person alleging it, the car dealer or car finance company, is going to bear the burden of proving that. Now, that's in itself going to be a little bit challenging because the fact that you've taken your car to a third-party garage in the first place presupposes there's something wrong with it. So that's going to make life a bit difficult from the car dealer or car finance point of view. But nonetheless, they will have to establish what it is the third-party garage did and how it is that they've contributed to or caused the fault that the customer now complains of. It's not going to be simple just to blame someone else. Now, I find that this is incredibly common. Almost every day I'm looking at responses from car finance companies and car dealers that raise these defences as if they are get out of jail free cards. What are you going to do if somebody does the same to you? If you get a letter from your car finance company or from a car dealer or from one of their lawyers that recites or relies upon one of these defences, drive-on damage, wear and tear, or third-party or unauthorised repairs, you are going to say to them, prove it. Please explain to me on what evidence you rely that proves that I am responsible for driving on after the car was defective, or that the parts have reached the end of their natural life, or that the repairs I had carried out by another garage has caused the problem. You just simply ask the question, why? I hope this has been useful. If you've got any questions, please contact us at Stormcatcher Law on 0333 700 7676 or email us at knowledge@stormcatcher.co.uk.